Good morning and welcome to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in beautiful Peckville, Pennsylvania, and I'm here with you each and every week at this time on this station to bring you the information you need regarding natural gas development and also more and more solar energy, solar development as well. I, Doug Clark, have not, do not, and you know it, will not ever, never have, never will, represent gas, pipeline, solar company. Don't do it. I represent the Pennsylvania land owner, property owner, oil and gas right owner, not oil and gas companies or solar companies in any way, any fashion. Again, never have and absolutely never will. I represent landowners for such things as gas lease negotiations, pipeline agreements, pipeline negotiations, royalty issues, unitization issues, lease termination issues, shut-in issues, surface use agreements, well pads, ponds, you name it. Anything and all things related to natural gas and now as well solar development. I've been working a lot on solar projects with many different clients, and I'm going to tell you, as I've said before, boy, put the pen down, pick up the phone. These solar agreements are very complicated. They tend to be books, not just 2-3 page oil and gas lease, which again is very complicated and you need to understand those terms. But the solar leases, 35 pages, 40 pages, 25 pages. These things are books. And this is new. This is new in Pennsylvania, and we need to make sure that you understand what you're signing, that you're protecting yourself, your property, you're maximizing compensation, and maximizing protections. I am telling you guys, this is different than gas. There are similarities in the contract, but certainly they are different. Substations, buildings, transmission easements. This is going to be a big deal. So you need to make sure. Think about the gas leases. Think about how many people say, boy, I wish I would have done something different. Boy, I wish I would have known then what I know now. I've had so many people say, boy, I wish I would have talked to you before I signed my gas lease. Guys, think about it. If you have a solar agreement, or if you get a solar agreement or a solar offer, think about it. Don't say, boy, I wish I would have known something different. Get the information now. Get it from someone who knows what they're doing, who's negotiating with these companies, who's dealing with the companies, who has seen a bunch of these agreements, seen the different markets, seen what's being offered, how different companies are proceeding. Get that assistance before you do anything. Don't say, boy, I wish I would have talked to somebody who knew something about solar before I signed my lease. Don't do that. There is somebody, and there's somebody who wants to work to help you. And, hey, self-serving, but I'll tell you, it's me. Call me, 570-307-0702, 570-307-0702. Call, put the pen down. We need to make sure that you have the information you need before you proceed. Just like you wish you would have had that with the gas lease in many cases, that information is out there. It's available now. Let's take advantage. These are serious agreements that should not be entered into without the assistance of legal counsel who understands these solar lease agreements, these solar leases, who has seen them, who has worked on them, who has negotiated, who's made these different changes. You need that assistance. These agreements typically run 20 to 40 years in the production phase with additional extensions of time. So these are agreements that are not only going to affect you typically, but future generations. You must maximize protections, compensations, and shield yourself from liability. And I'll tell you this, here's the big word that I hate in what I do, that all I want to do is eliminate this word from the future, from work-wise. I never, ever in the future when my client signs a document, I never want to have this S word stated. I want to, at all cost, avoid future surprise. We do not want to be surprised. How many people out there have been surprised about the gas development? Surprised that you're sitting there for 10, 15 years and have never seen a royalty, but the company still claims that you're under lease. Surprised that you were promised to be millionaires and you've only ever seen one well drilled and it's barely producing now. Surprised that a company went bankrupt. We want to eliminate surprises. We need to eliminate surprises. Surprised that you only have 1 acre out of your 100 acre, 200 acre, whatever it is in a unit. We want to protect against those things in solar. For example, of course, and just remember this, guys, don't fall into the trap when the landman who works for the company, not you, the landowner, comes out to you with the gas lease and says how rich you're going to be and this is the easiest money ever. Here, sign here, sign here. You can't believe they're paying this much. This is outrageous. This is crazy. You're going to be so rich. I wish I had your property. Blah, blah, blah. Here, sign, sign, sign. And people did it. And now they've seen that most people have not become rich. Now, some people have done very well, but most people have not seen the promises fulfilled when they were what they were told and what they were promised at the time of signing their lease. It just hasn't generally happened. So now here comes the solar landman who works for the solar company, not you, the landowner. And he or she is selling you and telling you how rich you're going to be, how great this is going to be, how this is the future. Well, maybe it is the future, maybe it's not. Time will tell. But one thing, and maybe you will be rich, maybe you won't. But I'll tell you this. Do we learn anything from the first landman who works for the company and not you, the landowner? Do we learn that, hey, just because these words are stated doesn't mean that that's what's going to occur? Just because I'm told that I'm going to have 100 acres in a gas unit and be developed doesn't mean that that's going to happen. But there are ways that you can defend against being held for years and years and years without production in a gas lease. And if you would have talked to an attorney and negotiated and you had leverage, you would have had that in your agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here each and every week at this time on this station and call me. Any and all oil and gas representation, solar leases, 570-307-0702. Call the office, put the pen down, get information, start with the review and consultation. See what we know, what I know, talk about what your options are and how best to proceed. So again, we saw the gas landman. Many people fell prey to these promises of future riches and not see them. And they were clouded by the shiny object and in the future riches, and so they just went ahead and signed. Hey, it sounds really good, let me sign. Well, now we have solar leases. And boy, let's hope we have learned. And again, these solar leases, I talked about this recently, you got to be careful. I'm going to tell you flat out, these companies may go bankrupt. May. You have to be prepared for that. Remember, Chesapeake went bankrupt. Multi-billion-dollar capital company went bankrupt. These solar companies could go bankrupt. I'm not saying they will, but they could. And you better darn well be defended against that. Do you want to have solar equipment strewn across your property and the company go bankrupt? Do you want to have a substation? Do you want to have above ground facilities? Do you want to have partial construction and the company go bankrupt? And now what do? Those are things that you have to address. That's just one item, guys. Just one item. Just one. But it's a darn serious item. So you have to be careful in these agreements. And when you read these agreements, when you understand these agreements, you see that the companies executing the agreement, entering into the agreement with you, the landowner, need to finance this project after you sign the document. Meaning they have to go out and get financing so they can build the project and do the project. You have to be careful about this situation. You can have mortgages, liens put on your property, which again may be acceptable, but it has to be done the right way. You better darn well know if you have a mortgage, if granting a solar lease will create any issues with your mortgage holder, the bank, whatever it may be. You better check on that. You better be careful. As I say, nothing is a problem until it's a problem. And if all of a sudden you got a problem because the bank and the mortgage holder says, hey, you weren't allowed to do that, well, now you got a problem. So you got to take care of that. And that's just one example. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You join me each and every week at this time on this station for All Things Marcellus, talking about today a little bit more of solar leases. But, here's something. I want to talk about a specific term. And because I've been seeing this, I've seen it in solar, and I've seen it in new gas lease offers to people, in new offers. And boy, it gets me fired up. And what it is, it's this mandatory mediation if there is a dispute under the gas lease or the solar lease. Mandatory mediation. Now, mediation, it doesn't sound like a terrible word. Hey, let's have a person or people mediate to see if we can reach an agreement. Here's the problem. Mediation is not binding. Mediation is expensive. Mediation is an obstacle, in my opinion, and I believe that very strongly. I would never, ever want to agree to mandatory mediation ever as part of a contract because you can always agree to mediation voluntarily in the future. But companies want to bind you to mediation. Why do they want to do that? Well, my opinion is pretty simple. They want to bind you to mediation because they don't want you to ultimately sue them for a violation of either a gas or a solar lease. Why do I say that? Well, if mediation is mandatory and you have a dispute, you say the company has breached my lease, the company has violated my agreement, then you want to bring a cause of action. Say, hey, this lease is over. And or you say, hey, you're cheating me on royalties, you're cheating me on payments. So instead of filing a lawsuit in court, you now have to first go to non-binding mediation. So what does that mean? Well, it means that you're going to have to hire a lawyer in most cases. And unfortunately, you really need one. And then that lawyer is going to have to do work. There's going to be paperwork. There's going to be submissions. There's going to be documents. There's going to be back and forth with the other side. Then you're going to have to pay for a mediator. And let's just say that in this case, it's only one mediator. Well, let me tell you, these mediators, they easily can be $500 an hour or more. So you have to pay half of that. So you could have a mediator that's $750, even $1,000 an hour. And so you'd be responsible for half of those fees. Again, too, you have to pay your attorney. Then you have to say, where is this mediation? And if you look, these agreements tend to place the mediations in convenient places, maybe for the company or the company's lawyers, like Harrisburg, Philadelphia, Pittsburgh, but not so convenient for you, the landowner, in Tioga, Bradford, Susquehanna, wherever, Wyoming. Now you got transportation issues. You got to pay for that. And then maybe you need people to spend a night at places. You got to pay for that. So then let's say you do all of these things and the mediator ultimately decides, hey, I think that you, landowner, are right. And I think that the company should release your lease. I think the company has cheated you on these royalty payments in some fashion. And I think that you should be awarded $50,000. Well, you've already spent $20,000, $25,000 on attorney fees, arbitration fees, costs, and expenses. And now the arbitrator, mediator, let's just say, says again, I think that you were cheated. I think you should get $50,000. Well, now you're $25,000 in. So you say, okay, well, maybe this was worth it. But the company says, well, Mr. Mediator, Ms. Mediator, I don't think so. I respectfully disagree with your opinion that we owe this landowner $50,000. I don't agree. So I'm not going to pay it. And since this is a non-binding mediation, I don't have to listen to you. I'm not bound by your decision that I should pay the landowner $50,000. So I'm just going to say, hey, thanks for your time, but I'm not going to do it. So now, switch over to the landowner. He's 25 grand in. He's 25 grand out of pocket. He has a mediator that says, hey, you should win 50, but he's 25 grand out already, and the company says, we decide we're not going to follow the mediator's ruling recommendation. We're not going to follow it because it's non-binding. So what does the landowner have to do now? Well, in many of these cases, in these leases, now the landowner, if he or she wants to fight, has to go to arbitration. So first you go to non-binding mediation, and you win, but the company says, nah, we don't want to pay on that, and it's non-binding, so we're not going to do it. So you're out 25 grand. Now you have to decide to go to arbitration. Well, arbitration is going to be even more time-consuming. And again, you're going to need a lawyer. And again, you're going to have to pay half the arbitrator fees. But usually in these arbitration provisions, there are 3 arbitrators involved, meaning you have to pay the fees, entire fees of one of the arbitrators, and you split the fee of the second arbitrator, and the company pays the fee of the third. So you now have a more complicated case. You have 3 different arbitrators. You need the attorney. You're going to have more filings. You may have filing fees. Now your expenses are going to be more than what they were in the mediation case. And again, in our example, the mediation case, your fees were $25,000. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station. So we have our landowner. He's out 25 grand in mediation. The mediator says, hey, you should be awarded $50,000 in damages. You were cheated on royalties. Company says, no, thank you. We're going to not accept your non-binding opinion. So now the landowner, if he wants to go to arbitration, again, has to pay for one arbitrator himself and half the fees of the second, pays again for the attorney. So if it was the same amount of work, and I assure you it would be more, it would be another, say, at least $25,000. So now you have $25,000 at least, and it's going to be more than that. So now the landowner, in a perfect world, if it went perfectly, would have $50,000 in expenses. And again, I want to say it would be more. And he is fighting for, according to the mediator, $50,000 in royalty losses. So who's going to bring that case? Because if you spend $50,000 and you don't win, you've just lost $50,000. If you spend $50,000 and you win $50,000, you just broke even and spent all that time and money to break even, and by the way, risked losing all the money you spent. Risked losing all that money. Now, also, again, these arbitrators are going to be more expensive. The cases are more time-consuming. There's more rules that are going to apply to arbitration. It means different filings. Those expenses are going to be more than what your mediation expenses are. So now you have a situation where you come to a person like me, and who wants to help you, and I look at your case and I say, hey, listen, you have, look, maybe I say, look, you probably have about a $50,000, if everything goes perfect, you could collect up to $50,000. The problem is you have to go to mediation. Then, again, non-binding, if you're successful, whatever, the company's going to say, no, now you got to go to arbitration. So I would never take that case because the risk is too high that you are going to have more expenses than what you collect, and you also always have the chance of being unsuccessful. So you've now ended up being in a position where, in my example, this example only, let's say that you were clearly cheated out of $50,000. Well, Because the company is making you go to mediation first, then kicks you over to arbitration, you've got yourself in a situation that you're probably never going to bring a claim for what we'll say is a clear $50,000 in royalty losses that you should receive. Your best hope probably is to push the company and say, hey, look, you owe me $50,000 and here's the reasons why. They say, oh, we disagree. We say, no, you're wrong. They say, fine, let's go to mediation. Your best hope is to try probably, well, I shouldn't say your best hope. Every case is different. But what has happened is they've put you in a situation where you're probably going to want to settle, if you can, earlier on for less money so you can avoid incurring legal fees for mediation and arbitration and mediator and arbitration fees. So now you're going to end up saying, look, I don't want to go too far in this because every day, every moment I go, every hour is costing me more money. Even though I'm confident they owe me $50,000, I'm going to settle for a number much less so I can reduce all my costs and expenses. And you probably are going to do that before you even go to mediation, probably. So the company, by putting in mandatory non-binding mediation into your gas lease or solar lease, followed up by mandatory arbitration, has put you in a position that you are not going to sue them from a practical standpoint, no matter how clear that you're right, that you have a legitimate, viable, and most likely successful lawsuit. You're not going to bring it unless it's for a lot of money, because the risk and the expenses of going through the mediation, then through the arbitration, are going to be very, very high. And you don't want to, at the end of the day, look and say, I'm going to have $50,000 in arbitration, mediation, and legal fees, and I'm fighting over $75,000, $50,000, even $100,000. Because if you lose, you've now lost $50,000 in fees and expenses. So please, guys, try. Well, first, call me. Let's figure this out, see what we can do. But if you don't, we need to eliminate mandatory mediation whenever we possibly can. And we also want to eliminate arbitration when we can. But boy, get rid of mediation. It does us no favors. And simply, if we want to mediate in the future, then you can always agree. There's nothing that stops us from saying, yeah, we'll mediate with you, company, in the future. When we have a dispute, it says, hey, do you want to go to a mediator? Sure, we'll do that if it's right. But you don't want to put yourself in that position today to evaluate some sort of breach or lawsuit that may occur in 5, 10, 15, 20 years into the future. So let's get rid of mediation whenever we possibly can, and let's avoid arbitration in any way we possibly can. And keep listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me each and every week at this time on this station. Any oil and gas representation, solar leases, call. Put the pen down. Call my office, 570-307-0702. Start with the review and consultation. Usually take 1 to 2 hours. Find out what you have in front of you. Find out what your options are and what we can do to make it better and to make sure you're making the right decisions. Ran this first segment long. 3 more to go. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can always join me each and every week at this time on this station for All Things Marcellus. And again, talking more and more solar this year because we're seeing a lot of solar development, and I have a lot of clients already who are working on collecting offers, negotiating offers. That's what you should be doing. Don't simply say, oh, I got a solar lease, where do I sign? I know listeners aren't doing that. So we can't do that. We just can't do that. These agreements are very serious, and what I'm seeing is I'm seeing a lot of discrepancy, meaning differences, in the types of offers that people are getting. As far as discrepancy in the amount of money, somebody may be offered $800. Somebody may be offered $1,500 an acre. Again, I'm not going to go into all the details about the compensation right now, but if you have a solar lease offer, you would understand what I'm talking about. But just to understand, here's the deal. Just like when companies were out and offering, hey, I'll give you $250 an acre for a gas lease, $500 an acre. Well, you want to generate competition. Just because one company is offering $500 doesn't mean another company won't offer $750. You want to make sure that you're maximizing that offer. So we're seeing initial offers to people, let's say $700, $800, $900 an acre for a solar lease, and I'm seeing others that are much higher than that. Now, I don't want to get, again, too specific on numbers because there's a lot of factors involved in these offers. And again, that's things we need to know about, and you learn that through experience. But there are projects that are going to be much smaller, 20, 30 acres, and then there's projects that are going to be hundreds of acres. And there may be different offers and different rates that a company is willing to pay based upon the size of the project, the location of the project. How far are you from the tie-in point? Is the tie-in point on your property? The aspects of the property, the slope, how much sun, all of these different things, angles, all of these different things come into play. So you do not, in my opinion, whenever possible, you don't want to limit yourself to one company. What does the company want to do? Limit you to just them. And how do they do that? One of the first things they want to try to do is maybe get you to sign a letter of intent. But you're going to have that pen down and you're going to have the phone in your hand. You're going to call me, 570-307-0702 at the Clark Law Firm. Because we're going to tell you, I'm going to tell you, okay, let's see about generating some other offers. Let's make sure that you're getting the highest possible offer you can, while simultaneously looking at this company and getting an idea of how confident we are in that company. Just because one company may pay you $100 more an acre may not make that exactly the right company for you. Maybe it's much less likely that this company will actually develop this project. Maybe this company that's offering you $100 more is not offering you the liability protection you need. Maybe they're not offering you the decommissioning or reclamation that you need. They're not assuring you that if they go bankrupt, you're going to have this property cleaned up. You have to look at the big picture. Well, again, maximizing your potential. So I am seeing offers just as simple as, we'll say a per acre rental. Now, these solar leases, they're not paying people royalties. They're paying like rentals where you would have, let's say 100 acres. They'll pay, and just use an easy number, $1,000 an acre. So that's $100,000. $1,000 an acre for 100 acres, $100,000. So they may say, we'll pay you $1,000 a year as a rental fee, and you have 100 acres. So that could be each year that you get $100,000. Well, that's great stuff. But there is a but. But there is a but. And that but is, well, there's a lot of buts actually. But one of the buts is, how do you know that they're going to use all 100 acres? And I'm going to tell you right off the bat, in every agreement I've looked at, you don't. You absolutely don't. You don't. Just because you have 100 acres, just because they scope out 100 acres as potential, does not mean you're going to get $100,000 or $1,000 an acre for all 100 acres. It doesn't mean that. But boy, it looks nice on a map. Oh, hey, here's your map. Here's your property. We got it on Google Earth, and we've squared out 100 acres that we're interested in, and we'll pay you $1,000 an acre for what we use, and that's going to be $100,000, and this is what we're interested in. But the agreement doesn't say they're going to use all 100 acres. It doesn't say that at all. It makes no commitment. So what do we need to do? We need to understand that. We need to talk about it. And we need to seek and negotiate a commitment from the company. And in my experience, in cases, and again, everything, you got to do these individually, but you may be able to negotiate a minimum acreage requirement. Why would you do that? To eliminate the S word, surprise. We want to eliminate surprise. So here a landowner says, I have 100 acres. They're offering me $1,000 an acre to rent my property for solar development. If this occurs, I will get $100,000, $1,000 an acre for 100 acres, $100,000 a year. That's great. But what if they only use 20 acres? And what if that 20 acres is in the prime area that you use for farming? Maybe it'd be hunting. Maybe it's the best 20 acres of your property, and that's all they use. So instead of getting 100,000 a year, now you're getting 20,000. It's not quite the same. And now maybe you have transmission lines, electric lines, pools. Maybe you have a building on your property. Maybe you have a substation. Google substations. Take a look. You thought you were going to get $100,000. You believed you were going to get $100,000 every year if this contract kicks in. But in reality, you're getting $20,000 because they only use 20 of the 100 acres. What if they use 15 acres? What if they use 10? What if the landman who works for the company, not you, the landowner, when you ask him or her and say, hey, you say 100. I listen to that Doug Clark on the radio, and he says, just because you say 100, you might just use 10. Landman says, whoa, no, we wouldn't do that. That's not what we do. Okay, then put it in the agreement. Put in the agreement a minimum amount of acreage that you're going to guarantee. A minimum amount of acreage or a minimum amount of money. Let's say that the landowner says, all right, I have 100 acres. You're going to pay me $1,000 an acre. And so in theory, if everything is used, that's $100,000. Maybe you say, okay, I will rent this to you or lease this to you at $1,000 an acre if you use 100 acres. But if you use 50 acres, it'll be $2,000 an acre. If you use 30 acres, it'll be $3,300 an acre. So the person's going to get $100,000. That's another possibility. But you need to be thinking about, okay, just like, oh, you have 200 acres. We're going to drill these wells. You're going to be so rich. And now here you are, 5 acres, 10 acres in a unit, and you're not rich. There's only one well. Solar leasing. You have 200 acres. We're going to build this big solar farm. We're going to give $1,000 a year. That's $200,000 every year. Fast forward until they start to use the agreement. Boom. Now you have 20 acres being used, and you're getting $20,000 a year. And your properties tore up. You got solar facilities in the middle, building maybe, substation maybe, who knows, roadway, traffic. And you know what you are now? Surprised. You're surprised. I didn't think that was going to happen. I didn't know that could happen. Well, we know that can happen. We need to defend against that happening. We have the information. We can use it. We use it in negotiation, and we make sure you don't get S-worded, surprised. We don't want you to be surprised. And think about it, guys. How many people in the gas leasing experience are now surprised or have been surprised? I mean, I talk to everyone all the time. Virtually everyone's surprised. What you were told and what happened weren't necessarily the same things. So we need to eliminate these surprises. And as I've talked to you, these solar agreements, they are complex. And there are a lot of potential surprises in there for you. And you got to be careful. I can't stress it enough how careful you need to be. People will make very bad decisions. And I have a feeling that they'll come back to bite some people. People will also leave hundreds of thousands of dollars on the table. Over the lifetimes of these contracts, people will leave millions of dollars out on the table over the lifetimes. We need to stop that. And thankfully, we can. If you get a solar lease, give me a call. Do a review and consultation. We'll talk about the lease, any lease offer, even letter of intent. We'll talk about it. We'll talk about exploring potentially involving other companies in negotiations and making sure that if this is right for you, you understand how we proceed. We want to proceed in a step-by-step logical fashion, and we want to get off this path if it ever appears it's not going to work. But if it appears it's going to work, we want to maximize it and make sure that you're doing the best you can in your situation. And if you don't call me, call somebody who has experience with these solar leases. somebody who's negotiated them, who's communicated with the companies. I'm going to tell you, I have a spreadsheet of every company that I've dealt with, and I keep that, and I use it for saying, hey, if you are you, Mr. So-and-so, or company so-and-so, XYZ, interested in this property, and this one, and this one. And I'll tell you, it's been working really well. And then we make decisions. Okay, do you want to proceed? How do we want to proceed? And we talk about making changes to the documents, negotiating the money. One of the things that I always want to do, that I always seek to do in every contract that I'm doing, is to make sure first that we're agreeing on these threshold big picture items. Length of time, compensation, 2 examples. In gas leases, royalty, deduction issues. Making sure that we have those in place first, and then we dive into the lease, the solar lease book, which is 25 to, 50 pages. We don't want to go into that nitty-gritty of detail until we know that this is going to work for you and that you're getting a good market price, that you're insulated, that you're not going to get took, and you're not going to be what? Surprised. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me, and I hope you do, each and every week at this time on this station. Guys, I have been doing this radio show since 2010. 2010. That's 11 years. I can't believe it. 11 years. So keep joining. We're not done. We're not done. There's all kinds of oil and gas lease issues out there, and now solar issues. We're not done. We got a lot to talk about. And fortunately for everyone, we have 2 more segments left. I'll be right back after this very important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me every week at this time on this station for All Things Marcellus, where I'm giving you, the landowner, the information you need regarding natural gas and, yes, now solar development as well. I'm telling you, my phone, I'm getting so many calls for solar development, which is great. It's exciting. It's an interesting thing to work on, but I'm telling you, it's got to be cautious. These things are very serious contracts, and you have to be cautious. And think again, like I've been saying, a lot of these companies are new. Look at their history. Look when they were created. Look that they need to get this financing. This could work out wonderfully for people. But you have to do it properly. You have to be careful. You have to avoid future surprise, because future surprises here could really be devastating. And I'm really concerned about that. And we're not even talking about, there's the other aspect of, the future surprise of money. We have to be careful that you are maximizing your money, not just say it's $1,000 an acre, could be more, could be a little less. Not just, hey, I want to get $1,500 an acre. Hey, listen, that's great. We always want to get more, but we also have to look at the project scope and size and the ability of the company to change the size, to make it smaller. Maybe you sign a lease thinking that you're going to get $100,000 a year, and it ends up that they just need a transmission easement across your property. And they end up using a very little, 5-10 acres. And that wasn't what you thought. You got to be careful. These documents must be negotiated in every way, And it's not just like a gas lease. There are similarities, but there are a lot of differences. And you need to negotiate. Have somebody negotiating for you who knows what they are doing, who's done it before, who's doing it now, who's interacted with the players in the game. It's not a game, it's serious business, but I think you know what I mean. We have to make sure we're getting you the best information and the best representation, and I'd like to hear from you. I think I can do that. 570, the Clark Law Firm, me, Attorney Doug Clark. You get one of these solar offers, a great way to start, and this is a great way to start with any offer. Do a review and consultation. You send me the lease offer, I look at it, review it, do what I need to do in the background. We get on the phone, do these with people all across the state, all across the country, and even in other countries. As long as the property is here in Pennsylvania, we get on the phone, we talk about it. I explain the good and the bad. I explain what I think, your best choices are. Give you your choices and then say what I think you should, my recommendations. Then it's up to you to decide. Maybe you want to have some additional representation. Maybe you don't. That's your decision. But why in the world, when you're getting something so important, whether it be a gas lease, pipeline agreement, surface use agreement, I don't care what agreement it is, or in a solar lease, do the review and consultation. I do all of these myself. You'll speak with me. I review everything beforehand, and I give you the information that I think you need to know from somebody who's doing this, who's doing it each and every day. So call 570-307-0702. Learn about reviews and consultations and find out if it's right for you. Then we'll get it set up if it is, and if it's not, that's okay. But for most people, I think it's going to be a very, very good thing. So 570, call Doug Clark, Clark Law Firm, 570-307-0702. Let's start with the review and consultation and then see where you go from there. You can't just sign these documents. I mean, you can, but please don't. Please don't. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me again each and every week at this time on this station. I want to talk again a little bit more, I'm talking about the area of the project. You think about, say you have a big farm, and I'm going to just do a crazy example here. You have 500-acre farm. The company says, hey, we outlined on your Google Earth map that we're giving you 200 acres that we think we want to use. That's not good enough, guys, because it doesn't mean they'll use it. And I'm harping on this because this is a major issue. This is a major issue. I, in my opinion, have seen solar lease offers that are covering what the offer looks like. The way it presents on paper is a heck of a lot better than what I think you're ultimately going to see should the company enter into the agreement, exercise their option to move forward with the agreement, and then develop the property. Because I can see, and I have reasons to believe, that although the landowner is seeing 200 acres, that they're saying, oh yeah, this is what we're interested in, and maybe that landowner is offered $1,000 an acre, and I'm using that because it's a nice round number, so that landowner, again, in that example, is going to get $200,000 a year. At least that's what they think. And I'm telling you, I have seen and I can tell that in cases like that, all 200 acres are not going to be used. In one example, one way, you want one way to test it? This is one of the things, you test by asking questions. So when the landman who works for the company and not you, the landowner, comes out to your 500-acre farm or whatever it is and says, we're going to use 200 acres, or they come out to your 100-acre farm and say, we're going to use 50. Or they say, here's the area that we want to use. We'll say, okay, then let's lock it in. If you're telling me that you're going to use 200 acres or you're interested in these 200 acres and you're giving me the impression it's a done deal, you're going to use 200, I'm going to get $200,000 a year then, well, let's put that in the agreement. The company, you guarantee to pay, if you move forward with the project, you guarantee to either use 200 acres or pay $1,000 an acre for 200 acres that you have the rights to use. If you use less, hey, that's okay, but you still pay $200,000. Then what do you get? Oh, well, we got to do some tests. We got to do a survey. Well, how about we agree that you'll use at least 150 acres? Well, we gotta survey, we gotta do studies. How about 100 acres? All right, guarantee me 100. Well, so you get my picture. You get the point. If they're presenting to you, oh yeah, we're interested. We're thinking we want to use this 200 acres. Okay, great. Put it in the agreement and see what they say. And look, I hope to heavens that they say, yeah, sure, we'll put it in there. But let's see what they say. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're talking solar leases today primarily, but a lot of these issues overlap with oil and gas leases. They really do. So when I talk about mediation, arbitration, we talk about maximizing agreements, we talk about reviews and consultations, those apply to every contract in the oil and gas industry and certainly to solar leases as well. So keep listening. Got one more segment left. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Call my office any oil and gas agreement, any oil and gas issue, any royalty disputes, give me a call. Solar leases, call. 570-307-0702. That's 570-307-0702. And keep listening each and every week at this time on this station for All Things Marcellus. One more segment left. It's a short one, but one more left. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, where I do not, have not, and will not represent oil or gas companies. And in case you haven't noticed, I'm not going to represent solar companies either. I'm going to represent landowners and property owners. We need to make sure we're not getting taken advantage of, you're not getting taken advantage of, and you're not surprised in the future when you thought everything looked rosy and now you're confronted with problems. And we also want to make sure that you're maximizing compensation for any agreement, maximizing the amount of money that you're going to receive. Pretty basic stuff, but not always the easiest thing. We need to make sure that we're aware of the market. We need to make sure that we understand your leverage. We need to make sure that we're generating competition whenever possible. My job is to get my clients the best agreement that I can, and if it's not going to work out, to figure that out as soon as possible and pull the plug. I do not want to see anyone have unnecessary expenses. I don't want to see anyone surprised. My job is to represent my client to the best of my ability to make sure that I'm using my experience, my history, and my knowledge to generate the best possible agreements or resolution in your case. Talking about compensation, again, just talk about compensation, I will, for a few minutes. I talked about, take a solar lease, but again, we could pretend it's a gas lease, but we're talking solar more today. So if you're offered, and again, I'm using $1,000 an acre. So clearly, how simple is it to say, well, I'd like to have more money per acre? Pretty darn simple. Instead of a mere 1,000, which isn't really mere, but instead of 1,000, I would like, let me guess, I'll say 1,200. Well, again, do you know that that's a good counter? Do you know what other companies are paying? But neither here nor there, let's just say it's pretty simple to look and say, oh, $1,000, I would like more. So anything $1,001 is more, 2,000 is a lot more. So I want to get more. That's pretty darn basic. But there are other aspects in negotiation of compensation. Again, you could negotiate for more money, but then all of a sudden find out instead of a 100-acre project at $1,000 an acre for $100,000, you negotiated, say, $1,500 an acre, but they're only using 10 acres. So now you're only getting $15,000. That, again, fairly basic stuff. You got to be aware that you might get snookered thinking you're getting a 100-acre project, but in turn it's only 10 or 15 or 20, maybe 30, whatever the number is. But that's one part of it. There are other parts. So again, the money itself, how much per acre? Then, how big is the project going to be? And can we guarantee minimum amount of project or minimum compensation each year? Again, the second one gets a little trickier because most people don't realize that there is a loophole the size of the Grand Canyon regarding making these projects smaller. So you have to be aware of that. But you listen to today's show, so you're aware of that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So you're aware of that. But you also need to be aware of these escalator provisions. And what do I mean by that? Well, another way to generate compensation for you, the landowner, is to have an escalation clause where over the course of the contract, the company has to pay you more money. So, you can think like inflation, cost of living, but these contracts, like I said before, I've seen them ranging so far, 20 to 40 years with extensions, meaning that once the project is up and running, a company may have a guaranteed right of 20 years. They may have a guaranteed right of 40 years. Doesn't mean it'll last that long, but that's how long they have the rights for. They also will build into these contracts company options to extend them. So you could have a base term of 40 years, and maybe the company can extend it 4 more times for 5 years each time. So that would add another 20 years to the contract if the company wanted it. So in that example, we'll just use that. You have a 40-year contract, and the company can extend it for a total of 20 more years, or 20 more years for a total of 60 years. Well, if you get $1,000 per acre, 60 years, and say again, we'll just use our example, $100,000. We'll say it's 100 acres, and they use that. Well, in 60 years from now, $100,000 is not going to be worth what it is today, nor will it be worth that in 50, 40, 30, 20. Money is going, with inflation, the cost, we need to adjust for that. So we need to add escalation provisions, provisions that will require over the course of the contract that the company has to pay you more money. So these things can be basic. Let's say the company offers you a 1% escalating provision. Well, so hey, 1%, I want 2%. Well, that's, hey, that makes sense. Pretty simple. But you need to understand and be able to calculate out what is the impact over the life of the contract at 1%, 2%, 1.5%, 3%. Maybe you can get 1.5. Maybe you can get 1.75. Maybe you can get 2. What you want to do is maximize that escalation provision. And can't do this, it's not easy to do over the radio, but maybe I'll do this one day and give an example. The amount of money that increases over 2% versus 1% is a pretty big deal. So when you're negotiating and your lawyer's negotiating these contracts, you want to make sure that you're very mindful of the escalation clause and maximizing it. When does it get kicked in? How often is it escalated? What type of impact is that going to have on the contract? Are you better to take a little less money in a per acre but an increased escalation clause? All of these things need to be looked at, considered, and reviewed when deciding how do I want to structure my contract. And I have seen and I have reviewed these projections where they do these projections of how much money a person could get paid under the solar lease if this amount of acres were used, and if it was a 1%, 1.5%, 2% escalator provision, or maybe even 2.5%. So I've seen the impact. You want to get a high escalation clause, highest as you can. So that's an important factor that many people are going to be unfamiliar with and may not be focusing on because they're looking at first the dollar price per acre, because that's simple and easy. Then hopefully they're looking at the guaranteed size of the project. Then we need to be looking at escalation provisions. Again, this is just in the small area of compensation. This isn't nowhere near talking about decommissioning, what's going to happen with cleanup, what happens if the company goes bankrupt, what happens with financing, what happens with future easements. All of these other things come into play, but we're just talking about compensation. So hopefully this gives you an idea of why I say, put the pen down, pick up the phone, give me a call. Let's do a review and consultation. Let's see where you stand. Get the information you need from somebody working for you, not the solar company, not the gas company, not the pipeline company, somebody working for you who does this for landowners, and find out what you have and what your options are. I'm up against it here. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me each and every week at this time on this station. And of course, and as always, I, Doug Clark, will not represent gas companies, pipeline companies, or solar companies. The landman works for the company, not you, the landowner. Stop signing bad agreements. Pick up the phone. Call me 570-307-0702. Have a great week, everyone. See you next week.